5 minutes. Generally, the city council will not take official action on items discussed at this time, but we may refer matters to staff or committee for a future report or direct the matter to be scheduled on an upcoming agenda. Does anybody want to speak?
Yes, I certainly would. The following are comments directly from the most recent motion for summary judgment for my lawsuit that's registered with the 8th District Court. They read as follows. There are no disputed materials of fact, issues of fact, and as a matter of law, defendant's sign ordinance and its bench sign ordinance component are supported by no constitutionally required evidence of legitimate government purpose. And the bench ordinance unconstitutionally confers limitless discretion on defendant, which is the city, to approve or disapprove petitions to rent benches on public property to express political, commercial, or other constitutionally protected speech in violation of due process. The council has stated unequivocally that it considered no evidence of any kind in support of its assertion that political speech signs placed in the curtilage of one's own home, yard signs, cause a traffic hazard. Many depositions are listed after that statement. The council stated unequivocally that it considered no empirical evidence of any kind in support of its assertion that political speech signs placed in the curtilage of one's own home, yard signs, diminish property values. Again, a whole bunch of depositions cited after that one of the council members seated in front of you. Council members stated under oath that they made no effort to determine whether yard signs caused a traffic hazard. Worse, they also swore under oath that they made no effort even to ask their own chief of police if such a connection existed. More deposition references. Chief of Police Greg Shermer stated at his deposition that in over 20 years as a cop and 17 years as a cop in Little Falls, he had never seen an accident caused by yard signs. Chief Shermer's deposition is cited after that statement. Plaintiff Hensel offers the statement of Joan Claybrook, head of the National Highway Traffic Safety Administration under President Carter, and an international consultant to governments and traffic safety, that she has never seen evidence that yard signs cause traffic accidents. Expressing one's opinion by placing signs in the curtilage of one's own home is speech protected under the First Amendment. Indeed, it is one of the most highly protected forms of speech. A special respect for individual liberty in the home has long been a part of this nation's culture and law, and has a special resonance when the government seeks to constrain a person's ability to speak there. That's from the Ledoux v. Galeo case, a landmark Supreme case. By admitting it had no evidence to support its allegation that yard signs cause a traffic hazard, or that yard signs ever cause property values to decline, council has in effect admitted its government purpose is a sham. Because Little Falls' new sign ordinance allows commercial speech considerably more sign area and type than it does in residential areas, the new sign ordinance favors commercial speech over political speech. The new sign ordinance makes numerous exceptions for churches, volunteer organizations, 501(c) organizations, such as Linden Hills, Estate, and other favored groups through a process that is essentially spot zoning. Finally, because the new sign ordinance is enforced almost entirely by complaints, common sense tells us that unpopular signs are far more likely to be complained of as aesthetic problems than popular ones are. Little Falls does not find visual clutter a problem in any place but Robin Hensel's front yard. Aesthetics is no more legitimate government purpose in this case than traffic hazard or property values. The Ledoux court stated that visual clutter is not an illicit constitutional purpose per se, but found for the plaintiff against the city anyway because of the compelling First Amendment interest in protecting political speech via home yard signs. The interest in avoiding visual clutter is largely self-enforcing because no homeowner wishes to deprecate the value of his or her home. In conclusion, it is that even if aesthetics are a possible motive for legislative action, they do not trump First Amendment rights. Because the uncontroverted facts show the Little Falls new sign ordinance advances no sufficient government purposes, That ordinance fails to meet the minimum requirements necessary when government attempts to limit speech. Viewpoint discrimination by government is per se a violation of the First Amendment.
Anybody else want to speak?
Yes, I would like to read something from the website of KSDP Eyewitness News about the drones. The state is competing against 36 other states to host one of a half a dozen test sites for drones. It's the Minnesota Department of Employment and Economic Development which is promoting it. The state agency that tracks employment and helps the unemployed says it applied not with an eye toward defense, but dollars, the hope that an economic windfall would follow unmanned aircraft to Minnesota soil. A study cited by DEED that was conducted by the Association for Unmanned Vehicle Systems International, a group which promotes drone use, estimated $142 million in economic impact in Minnesota between 2015 and 2017, 730 jobs created, and more than $1.68 million in taxes generated because of the integration of unmanned drones into domestic uses. Other agencies partnering with DEED on the application are MnDOT, Duluth International Airport, Monaco Air, Morrison County Community Development, Minnesota SCU, U of M, UAV Laboratory, MSU Mankato Aviation, Northland Community and Technical College Aerospace Program.